Okay, so the recording started. Which would you like to start with your Jack and Law?
I'm getting some sort of high-pitched sound going on here, Manjo.
Okay, let me just mute everyone else. Hang on. So I've muted everyone. So if you need to say something, you need to unmute yourself. Is that better now?
Yeah, I'm not getting any interference now, but yeah, no, that's better. I am running Zoom on an iPad, okay. So I can't share my screen. I'm just switching now to my desktop, so I can share my screen with the PowerPoint presentation.
Is there anyone from your group who can show?
I can probably do that.
You can do that?
Andrew.
Yeah,
I emailed it to you. I emailed it to you, Jack, about an hour ago.
Yep, I got it. Just have to figure out how to do that.
Okay, very good.
Share screen. How do I? How do I choose?
At the bottom, Jack, there is a icon which says share screen. The first thing you need to do is open the PowerPoint file. And once done that, you can then just screen, and it will allow you to choose whatever you'd like to share. But you need to open the slide first.
Find it.
I'm just I promise you my computer myself, so let's see what I could do.
What do I got here?
Okay, good. You've started to share the screen, Jack.
Okay.
Here.
So is it visible now, the presentation?
It is visible. I can see it.
Yep. Could be bigger, Jack, if you could make it bigger, mate. Maximize it, perhaps.
Maximize.
There you go. Bingo. That's it. Okay, well, we're ready to go, Manjo, if you're ready to hear us.
Yep, I could hear you. Go ahead.
Okay, very good. Thanks for joining us. Tonight we're talking about disputes in the South China Sea. Going to give a factual background to the disputes, also identify the legal issues, public international law issues that pertain to the problem, and lastly, we're going to talk about the rules and principles that would be applied to the situation. So, starting first and foremost with the factual background, the South China Sea is a body of water in the western reaches of the Pacific Ocean. Getting interference there. It's bordered by a number of countries: China, Taiwan, Vietnam, Philippines, Malaysia, Brunei. It's a pretty significant water body in that it has been a major trade route ever since the 8th century, possibly even beforehand. It's certainly still a major trade route now. It's said to see the passage of more than half of the world's merchant fleet tonnage in terms of trade tonnage that passes through the water body. So there's a pretty significant strategic element to the water body itself. not only the fact that it hosts that sort of function, it hosts a lot of exploitable resources, natural gas, oil reserves, and fish stocks. So there's been disputes that have risen between the states that border that particular water body. There's disputes as to territorial sovereignty of islands and other physical features in the South China Sea, such as the Scarborough Shoal. Jack, if you just go to the next slide. So you'll see here the Spratly Islands, Paracel Islands, Scarborough Shoal. They're showing here on this map of the South China Sea. There's various disputes between the various states that border that water body. There's various disputes between them regards who actually has title to those territories. In May 2009, Malaysia and Vietnam made a joint submission to the United Nations Commission on the limits of the continental shelf, UNCLCS, and each of those states was claiming a continental shelf which conflicts with the claims of other states, not conflicting amongst themselves, but conflicting amongst other states. One of those states is China. A very powerful nation, obviously, ever more so as the years go by. So China's response was that Malaysia and Vietnam's claims seriously infringe China's sovereign rights and jurisdiction in the South China Sea. China is claiming historic rights over much of what Malaysia and Vietnam are claiming in their submission, and relies on mapping known as the 9-dashed line mapping, which is mapping produced by former governments of China. And it's shown there in that particular slide. Other states, Philippines, for example, are making claims to other parts or other bodies, other territories in the South China Sea that are being counterclaimed by other states. Moving on to the next slide, China. There's a number of things that are happening in the South China Sea in terms of actions. China is said to be militarising the South China Sea and precluding access to Scarborough Shoal to other states, and states, and any number of states are claiming that they don't have the right to do that. Scarborough Shoal is not actually their territory. They're also building man-made islands and reclaiming parts of land and forming man-made territories in the South China Sea. Contrary to what other states claim is their rights and entitlements. In January 2013, the Philippines submitted a statement of claim to the UN Permanent Court of Arbitration, seeking a ruling about China's actions in relation to the laws of the sea. That's just one element, as we'll see in the next slide. That's just one of the issues, laws of the sea, but other issues are also sovereignty. The primary issue is sovereignty. So there are states with claims and counterclaims regarding territorial sovereignty over islands in the South China Sea. So that's the primary issue. And a related issue to that is that some states are acting on assumptions of rights and entitlements in the South China Sea, which call for considerations of the laws of the sea. And also, this is one that I'm not going to delve into, but there's also question marks over the behaviour of states towards other states in terms of intimidatory and aggressive behaviour towards other states. So we're just going to focus on the sovereignty issue and the laws of the sea issue first. So sovereignty, there's two cases which are pretty relevant here. The Norway against Denmark case is from 1933, otherwise known as the legal status of Eastern Greenland case. It says a claim to sovereignty based not upon some particular act or title, such as a treaty of cession, but merely upon continued display of authority, involves two elements, each of which must be shown to exist. Number one, the intention and will to act as sovereign. Number two, some actual exercise or display of such authority. Now, in that case, the judgment was given for Denmark because they were recognised as having regulated for such activities as fishing and hunting, and also giving access to the island to the British and French nationals. So they exercised some sort of dominion over that territory, and that was enough in that particular case. Another case, and this is particularly relevant in the South China Sea scenario, is Indonesia against Malaysia, and it's only as recent as 2002. So there was disputes that regards a couple of islands in the vicinity of those two states. In that case, the court found Indonesia's measures over the disputed areas to consist largely in acts of private individuals and not official acts, such as making law and regulating activities in other areas, whereas Malaysia exercised legislative, administrative and quasi-judicial acts, which, though few in number, were diverse in character, and so the court awarded for Malaysia in that case. Now, I've quoted there from the textbook, our course textbook there on page 205. Interestingly, also in that case, it said in the case of very small islands which are uninhabited or not permanently inhabited, like the islands that were in dispute, where there's little economic importance, or at least until recently, effectiveness in that equation is generally a pretty scarce thing to make out, or difficult to make out. So that's the issue of sovereignty. Those two particular cases are highly relevant. In regards to the laws of the sea, there's a United Nations Convention on the Law of the Sea, entered into force in 1994. It sets a framework for rights and entitlements and obligations also on the flip side in respect of territorial seas, exclusive economic zones, continental shelves and the high seas. So this is relevant here alongside the issues of sovereignty, which we've touched on. So in respect of territorial seas and EEZs as they're known, and continental shelves, the convention says, or Article 3 of the convention says, every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles, measured from baselines determined in accordance with this convention. Article 5 of that same convention defines the normal baseline for that purpose as the low water line along the coast, as marked on large-scale charts officially recognised by the coastal state. The convention then provides several qualifications to the normal baseline, including for reefs, bays, ports, roadsteads and low tide elevations. In the case of a low tide elevation, and this is relevant in this case because with Scarborough Shoal is arguably fitting of that definition. In the case of a low tide elevation being a naturally formed area of land which is surrounded by and above water at low tide but submerged at high tide, it will constitute the baseline for establishing the breadth of the territorial sea and the EEZ for that purpose, for that matter, if it is situated wholly or partly at a distance not exceeding the breadth of the territorial sea from the mainland or an island. A low tide elevation situated below 12 nautical miles from the low water line, or beyond 12 nautical miles from the low water line of the mainland or an island, cannot constitute the baseline for establishing the territorial sea or EEZ. It then goes on to talk about instances of an island. It says an island being a naturally formed area of land, and this is relevant here. It has to be naturally formed. So the examples of China building islands, man-made islands in the South China Sea is not relevant here. It's not officially an island per the provisions of the convention. So an island being a naturally formed area of land surrounded by water but not submerged at high tide can give rise to a territorial sea and an EEZ for that matter, provided it is not merely a rock incapable of sustaining human habitation or economic life of its own. So the island has to be capable of sustaining human habitation and economic life of its own. In regards to the EEZ, the exclusive economic zone, Article 55 defines it as an area beyond and adjacent to the territorial sea, and Article 57 states that the EEZ shall not extend beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured. So there's a baseline in respect of the territorial sea that's also common to the baseline that's relevant to the to the EEZ.
Andrew, can you wrap up the presentation in 3 minutes, please?
Yes, definitely. I'm nearly there. And the last matter is in respect of the continental shelf, and this is relevant because Malaysia and Vietnam made a submission to the United Nations Commission on the limits of the continental shelf. It says that this is directly from Article 76 of the United Nations Convention on the Law of the Sea. It says the continental shelf of a coastal state comprises the seabed and subsoil of the submarine areas that extend beyond its territorial sea, so beyond the territorial sea, throughout the natural prolongation of its land territory to the outer edge of the continental margin, or to a distance of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, where the outer edge of the continental margin does not extend up to that distance. So those are the key laws of the sea that relate to the disputes between the states in the South China Sea. They matters upon which a permanent court of arbitration made a ruling in respect of Philippines and China not all that long ago, literally 6 months ago or so. That particular ruling, I won't go into it, it's not part of our Zoom session, but that particular ruling didn't cover matters of sovereignty because that particular court under that particular convention didn't have jurisdiction to hear a matter pertaining to a sovereignty dispute, but certainly the court did hear the matters pertaining to the laws of the sea, and they made an award in respect of that. So they're the key issues: sovereignty and the laws of the sea. That's me, Manjo.
Was there going to be something from Solito?
No.
No.
Okay. Thank you. So thank you to both of you for the presentation, and I'm very happy about the fact that you actually used images as well to enhance the presentation and allow us to really appreciate, what the conflict was about. And that's good. I also saw that the presentation was quite thorough in terms of presenting the factual background, as well as some other facts which would be relevant, especially in relation to the decision made by the tribunal. And then you also cited a lot of the legal provisions that would be relevant to the factual background. My main comment would be this. And this is also what happened in relation to the website that you created. There is an enumeration of the pertinent legal provisions under the UNCLOS. And if you do that, it's a barrage of legal provisions. It's difficult for the reader to figure out what the relevance or the importance of those legal provisions are. And so therefore, I think it would be more helpful to you, if you've already properly identified what the key legal issues are, to focus on what you think are key provisions that help us in terms of resolving the conflicting claims by the state. So don't just enumerate what the legal provisions are. You need to be able to link the legal provisions to the competing claims. Now, so that's one. So don't just enumerate the legal provisions. Now, the question I'd like to ask is, obviously, there are competing claims from the Philippines and Malaysia as well. What is the basis for the claim of Malaysia and the Philippines as opposed to that of China?
Good question. Well, certainly in respect to China, they're pointing to the 9-dash line mapping, which was mapping produced as far back as 1946 or 48 or something. So mapping produced by the Chinese government of the day, which they're relying upon, and they certainly did in respect of the Permanent Court of Arbitration, the tribunal in respect of the laws of the sea matter. That's what they were relying upon as the basis for their sovereignty claims. The other nations, Jack, you got views on the Philippines and Malaysia's claims as to how they support those?
Yeah, the basis of Malaysia, Vietnam, and the Philippines are basically based on the provision of UNCLOS to have their rights, EEZ rights in particular, according to the convention. One argument of the Philippines that the China hasn't really argued what is they're claiming, because according to that case, it's based on history, like, you know, from the Ming Dynasty, and they're claiming to accept. They are saying that they are claiming territorial rights on those features. So if they are claiming territorial rights on those features, are those features capable of generating EEZ based on those characteristics, those issues? So the Philippines is claiming that those features, because of their characteristics, they are rifts, rocks formation, are not entitled to EEZ. So that basically nullifies the 9-dash line because it has no basis.
Let me clarify. These are obviously natural islands. So there was a reference made earlier. There was a suggestion made earlier that China has started to build some artificial reefs near these islands or even on the islands themselves. But the fact remains that these are natural islands. So therefore, they actually can comprise the territory of a state. Now, the question I'd like to ask factually for now is this. Isn't it the fact that in relation to some of these natural islands, not artificial islands, in relation to some of these natural islands, the other states, whether it's Malaysia, Vietnam, or the Philippines, have actually occupied these islands by having people being present there, whether they're soldiers or civilians. And if that is the case, what does that do to the claim of China?
Yeah, no, definitely. There's definitely been some evidence put forward on behalf of states other than China that some of those disputed islands have been occupied in the past and possibly even presently. I'm not too sure. I came across that in the tribunal's award in respect of the laws of the sea matters. So yes, definitely there's been some claims that they've been inhabited or at least possibly still inhabited. What does it do to China's claims? Going back to those two cases that I cited in respect of sovereignty, the Eastern Greenland case and the Malaysia versus Indonesia case from as recently as 2002, the key issue in the court's award there was that the state claiming sovereignty of those lands had to demonstrate that they were acting in a manner that was evident, that showed that they assumed, if you like, that they had rightful sovereignty over those, and they were making laws and decisions in respect of those territories that could only be compatible with the assumption that they actually had sovereignty over those islands. So, if Philippines, for example, was acting in such a manner in respect of the Spratlys, because they are part of the disputed territories, if they were acting in that manner in respect of the Spratlys, because some Filipino nationals were resident on that island or those islands, then that would, in my view, at least applying those particular case law, it blows the Chinese case out of the water, really. Because China's relying on something probably a hell of a lot weaker than that, and they're merely just pointing to a map, this 9-dash line mapping. Whereas if the Philippines, as an example, are pointing to having had some of their residents inhabit those islands, then that's much more likely to win favour with the court based on the precedents of those cases we mentioned.
So let me just clarify, because I'm getting confused here. Is the dispute mainly about the South China Sea, or is it the South China Sea as a result of islands being located in the South China Sea?
The dispute's about islands in the South China Sea, namely the Spratly Islands and the Paracel Islands. They're the two main ones. I think they're archipelagos. I think they're actually bodies of, or a number of islands, not just one island. But certainly they're central to the dispute. Also Scarborough Shoal, which is not an island. It's actually a low tide elevation, as I understand it to be under the convention. So definitely the disputes are regards the territories or those islands and low tide elevations in the South China Sea. That's without question that there's disputes about that.
That's clear. Now, the question I have is, given the fact that some of the nationals of these states, competing states, apart from China, seem to have actually inhabited on these islands, what has actually happened factually? Not a legal question for now, just as a factual question. Do they remain there, or have they been ejected or ousted by the Chinese military from these islands, such as the Spratlys or the Paracel Islands?
Jack, do you...
Yeah, there's one news about a year ago that Chinese government sent some people entertain the soldiers located in Spratly Island. So it was temporary, basically. That was a year ago. So does that constitute historical rights that they are exercising jurisdiction? So the answer is they have not. Yeah. I'm not aware that they have sent any resident or people to reside permanently to those islands.
So hang on, so there are still nationals of the other states apart from China that continue to inhabit those islands?
Well, inhabit in the sense that they live there, or just...
Yeah, that says they live there.
Well, now that I know, one thing I know is that there's Chinese sent some soldiers to guard the area, but not to live there.
Yeah.
Wait, hang on. We're not talking of Chinese nationals yet, or Chinese soldiers. Yeah. Prior to the Chinese occupation of these islands, were there nationals of other states, apart from China, who inhabited or lived in these islands?
Some Filipinos are living in Kalayaan Islands, but that was just...
Let's just talk of the Paracel and the Spratly, so we don't get confused.
Yeah, I believe so. I came across something in the award from the tribunal in respect of the laws of the sea, where they were presenting the facts, and the Philippines had contested that on some of the islands, and I'm not sure exactly which ones, they had fishermen resident on those islands at least for certain periods of time, if not at the current time of the award. But they had some Filipino nationals resident on those islands for the purposes of plying their trade, which is fishing.
If that is the case, if there, for example, were Filipino nationals residing on those islands, what happened then factually? Were they ejected from the islands by the Chinese military?
I haven't come across anything to that effect, Manjo.
There are Chinese soldiers there, and at the same time, there are Filipino nationals living in the island?
Don't believe so. Certainly, China has heavily militarized the South China Sea. If there, I haven't come across anything that definitively answers your question, unfortunately. But if just based upon what I've read about China's behaviour in the South China Sea, I'm very confident that there aren't any bodies, there aren't any islands that China are now exercising control over that still house residents from other nations. I'm sure of it, because
the thing is, if there in fact were or are nationals of other states living on those islands, and assuming that those states are actually also asserting a claim of sovereignty over those islands, wouldn't the act of China in terms of ousting these nationals or exercising control over these islands and the exclusion of other states constitute a use of force?
Yes.
Which violates customary international law?
Yes, it would. Go on, Jack.
Yeah, the thing is, China's saying that it is the other nations who's violated China's rights. They're claiming that those nationals other than China's are not even allowed to stay on those islands. So the question is, who really owns those islands?
Okay, so my suggestion to the group is there are still some facts which are quite missing. Given what I've articulated now, what I've been asking, whether there were other nationals of other states that resided there, whether or not they've been evicted, and I think these should have been supplied in the facts because they lead to other legal issues, whether or not the attempt of China to exercise sovereignty over these islands may actually constitute a use of force, especially so if there is a prior claim of other states. So that's one. Okay, so I'm just going to leave it for now. I'd like you to think about it. The other question I have is in relation to the law of the sea and in relation to the exclusive economic zone. As far as China is concerned, is it now broadening its claim on the basis of mainland China, the main island of China, and they have the dash line, or can they now extend their exclusive economic zone on the basis of where these islands reside or are located?
Yeah.
So you know what I mean? As far as
I know. Yep.
Yeah. Okay. So how is that working now?
Well, firstly, China is certainly aware of their of the definitions under the Convention of the Law of the Sea. They're a signatory to the convention, so they know with the construction of these artificial islands that they're not capable of constituting an island for the purpose of that convention. So they don't afford any or generate any territorial sea or EEZ therefore. So they're not constructing artificial islands for that purpose, but certainly they're claiming sovereignty over the Spratlys and Paracels because those particular features, those islands, are capable of extending what would otherwise be China's territorial sea and EEZ.
So the baseline has now in fact been extended on the basis of islands.
That's my understanding. So well, it's highly topical at the moment, particularly since Trump's come into power. He's singled out China for their for their behaviour in the South China Sea, and he said it's not right for us to just allow states to extend the boundaries of their territory in this particular manner. So there's certainly some pretty powerful states out there that are seeing it as nothing more than as a land grab, and an unlawful one at that. So I think China has got many more enemies on this particular issue than they have friends. So at least anecdotally, you could assume that perhaps they're acting unlawfully. So so certainly that's part of the motivation, as I understand it, for why they're wanting to lay claim to those particular islands.
Okay, thank you very much. So I'm not going to be asking more questions because we have a second group coming up, and we've kind of gone beyond the time that was allocated for this. Well done. So thank you very much. You did really well. Thanks.
Thank you. Thank you.
I'd like to give the floor now to the next group that will be presenting, the Falkland Islands group. Thank you.
Can you hear us, Manjo?
I could, yes.
Right. We're just sharing the screen right now. Okay. We're starting now.
So good evening, everyone. My name is Caitlin Peterson, and these are my colleagues, Kirsty Monroe.
Where's that coming from?
Can we mute? Just give us 2 seconds.
And we just have some technical difficulties at the moment.
So we won't be able to hear you, but just let us know if you can start hearing the buzzing again. Or it's still on
mute.
There isn't any buzzing.
Unmute it.
It's unmuted. No, that one doesn't hear. Can someone give us a thumbs up if you can hear us?
I could hear you.
Yeah, okay. Thank you. So my name is Caitlin Peterson. These are my colleagues, Kirsty Monroe and Patrick Fitzgerald, and we are the Falkland Islands group. So the Falkland Islands conflict is between the United Kingdom and Argentina and encompasses both modern international law principles and historic international legal arguments that were established prior to the enactment of the United Nations Charter in 1951. The conflict for the Falkland Islands continues to raise legal issues as to which state, with that being either the United Kingdom or Argentina, may lay claim to sovereignty over the island. So, sorry. There we go. So in tonight's presentation, we will discuss the historic and history and events leading up to the conflict, issues raised by the conflict, and the legal arguments that can be applied in determining sovereignty. The presentation will then conclude with questions from the audience.
The history and politics leading to Argentina's invasion of the Falkland Islands, on the 2nd of April 1982, is long and construed. Both United Kingdom, UK, and Argentina claim to sovereignty rights in historic ownership of the islands, which is, as I'm about to demonstrate, is further complicated by this history. The history surrounding the discovery and subsequent possession of the islands dates back to the early 1500s and 1600s. When the UK and France made their first recorded landings on the islands in 1690 and 1701 respectively. The first settlement of the islands was established by the French, who later sold their claim to the islands to Spain in 1767. Since the early 1800s, when the Spanish rule of South America collapsed, the Argentinians inherited possession of the islands. However, in 1832, the United Kingdom contended Argentina's claim and asserted its sovereignty rights over the islands successfully, maintaining territorial sovereignty over the islands until Argentinian forces invaded the islands in 1982. Whilst Britain rests its claim on its long-term administration of the islands and on the principle of self-determination, Argentina's claim of sovereignty rests on the fact that they gained possession of the islands from Spain, and therefore the UK's occupation of the islands was in breach of Article 2.4 of the UN Charter. That is, all members shall refrain in their international relations from the threat or use of force against territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. Argentina commenced its attacks to reclaim the islands on the 2nd of April 1982, with the UK responding by commencing their own military response to maintain possession of the islands.
So we'll move on to the legal issues that have been identified for this case. The first one is the sovereignty and territorial dispute. So the first legal issue presented is one of a sovereignty dispute or territorial dispute over who has the rights to sovereignty over the Falkland Islands. Sovereignty is the authority of a state to govern itself or another state or territory. In this matter, both Argentina and the United Kingdom are in conflict over who has the right to govern the Falkland Islands. To make matters more difficult, both states are staking their claim to the Falkland Islands based on conflicting legal principles, with some of Argentina's claims relying on 15th century law. Accordingly, the United Nations is obligated to maintaining international peace and security, as stated in Article 1 of the Charter, has not been able to resolve this territorial dispute. The second legal issue presented is a matter of self-determination. Self-determination, which can be defined as the people's right to be allowed to determine freely their own political status, presents the issue that in context of the United Nations decolonisation process, it is about state formation applying to territories and not to peoples. Furthermore, the issue presents the confusion over who is entitled to claim the right of self-determination. Is it a group, a people, or a nation? The United Kingdom claims the island's population has the right to self-determination, and since the 2013 referendum, where 99.8% of the Falkland Islands voted to remain with the United Kingdom, the United Kingdom remains firm on its claim that all peoples have the right to self-determination, and as such, it claims that the inhabitants want the Falklands to remain British.
So finally, let's discuss the legal principles involved in this dispute. So before considering United Nations resolutions and the Montevideo Convention, let's first examine the arguments being made by both states, starting with the United Kingdom. Acquisition by occupation typically occurs where a territory is considered terra nullius, or where occupation has occurred but has since been abandoned. In the Island of Palma's case, that being the Netherlands and the United States of America 1928, The court asserted 838 that international law in the 19th century laid down the principle that occupation to constitute a claim to territorial sovereignty offers certain guarantees to other states and their nationals. Discovery alone without any subsequent act alone cannot suffice to prove sovereignty. Furthermore, in Norway and Denmark in 1933, the court again asserted that a claim to sovereignty based not upon some particular act or title such as a treaty or cession, but merely upon the continued display of authority involves two elements that which must be shown to exist: the intention and will to act as a sovereign and some actual exercise or display of such authority. The UK continues to assert their intention and will to act as the sovereign over the islands, and their continued occupation since 1833 follows their claim of terra nullius of the islands. Acquisition by prescription is where a state acquires title over a territory that is already occupied by another state, provided it can prove that the previous occupier acquiesced title over the territory. In the Malaysian-Singapore 2008 case, the court asserted at 121 that under certain circumstances, sovereignty over the territory might pass as a result of the failure of a state which has sovereignty to respond to conduct attached to their sovereign of the other state. Manifestations of the display of sovereignty may call for a response if they are not to be opposable to the state in question. The UK therefore argues that Spain acquiesced its right to sovereignty over the Falkland Islands when Spain abandoned the islands in 1811. The United Kingdom re-established control over the Falkland Islands in 1833. Spain at that time had not recognised Argentina as an independent state, and therefore they still had sovereignty over the islands. By Spain's actions in not objecting to the United Kingdom's occupation of the islands, it can be argued that the United Kingdom acquiesced the islands by prescription. Lastly, self-determination. Under the Declaration of the Granting of Independence to Colonial Countries and Peoples United Nations Resolution 1514, all peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Furthermore, the United Nations supports the equal rights and self-determination of peoples as established in the Declaration on Principles of International Law concerning friendly relations and cooperation among states, in accordance with the Charter of the United Nations, where it affirms the establishment of a sovereign and independent state, the free association of integration with an independent state, or the emergence of other political states freely determined by the people constitute modes of implementing the right of self-determination by that people. In 2013, the Falkland Islands held a referendum as exercise of self-determination, when 99.8% voted to remain with the UK, further supporting their claim of sovereignty over the islands. In comparison to the UK, whilst also arguing against their claims, Argentina makes two further claims of their own. The first is utilitarius juris, a customary international law which preserves the territories and boundaries of former colonies upon independence of a new state. The UJP principle has been explored by the ICJ and is explained further in the frontier dispute, which is the Burkina Faso and Republic of Mali case. Lastly, Argentina also makes another claim, being that of geographical proximity, which they believe further substantiates their claim to the island in consideration again of the Island of Palmas case.
Sovereignty territorial dispute. The approval of the UN Resolution 1514, UN Resolution 2065, and UN Resolution 3160 have sought to create and pave way for negotiation of either self-determination as to remain as part of the UK, or to seek to decolonise and become part of the territory of Argentina, and the immediate request to cease all use of force and commence peaceful negotiations between each state. UN Resolution 1514, put forward by the Decolonisation Committee, that is, Committee of 24, sought to resolve the question of sovereignty and grant independence of the island. The resolution highlighted that all peoples have the right to self-determination, at the same time acknowledging a people's rights to self-determination should not impair the territorial integrity of the states. Consideration was further given to the emergence of a sovereign and independent state, the circumstances needed for a self-determined, self-governing territory to arise. This resolution was unsuccessful and seeking to resolve the debate of sovereignty over the island, and was not revisited until 1982, the month-long Falkland Islands War. UN Resolution 2065, adopted after the failure of Resolution 1514, sought to immediately call to cease force between both the UK and Argentina and commence peaceful negotiations, which both states ignored despite the political pressure applied by the UN. UN Resolution 3160, put forward by Argentina, requested that the UN again review the question of sovereignty of the island after 8 years to recommence that question. The resolution approved the declaration on granting of independence to colonial countries and peoples relating to the island. It declared the need to accelerate negotiation talks between both the UK and Argentina, which urged without delay and that both governments reported by no later than the 29th session of the UN with its recommended negotiation terms. That was in 1973, 14th of December.
And finally, the criteria for statehood. The 1933 Montevideo Convention on the Rights and Duties of States is commonly referred to as a principle setting out the necessary criteria for statehood. The Montevideo Convention further provides a definition that the states as a sole person, that a state is a sole person in the eyes of international law. Article 1 of the Montevideo Convention stipulates that a state as a person of international law should possess the following qualifications: that is, a permanent population, a defined territory, a government, and capacity to enter into relations with other states. The Montevideo Convention, although it was signed as a treaty between the United States of America, Peru, and Brazil, and as such only binds the parties to the treaty, however, has been recognised under customary international law and has been used as a foundation in establishing statehood through various other cases. Whilst it can be claimed that the UK fulfils the criteria for statehood with regards to its permanent population, defined territory, its government, and its capacity to enter into relations with other states with the Falkland Islands, Argentina also claims that given the opportunity, it would be able to satisfy all the criteria under the Montevideo Convention.
So thank you all for listening, and we'll now move on to the questions segment of this presentation. If you just give me a moment, I'm going to take away the videos, that way we're not getting any feedback. Just give us a moment.
Caitlin, can you wrap it up in about 2 minutes? Can you wrap up the presentation in 2 minutes?
They're done.
They were about to discuss the answers, I think.
No, they were calling for questions.
Oh, okay. Caitlin, is your presentation done, or were you planning on discussing your answers to your questions as well?
Just give us, sorry, we're just trying to work out the computer. We're a bit flustered. The system's just down. If you'll just give us 2 seconds, we'll be back to you. All right, so Kirsten's just going to kick us off with our first question.
Okay. So the first question, discussion question that we raised was with regards to the Montevideo Convention, and how does the Montevideo Convention support the UK's claim to statehood? The answer that we provided was that it is argued that Article 1 of the Montevideo Convention, which sets the customary international law criterion for statehood, supports the United Kingdom's claim to territorial sovereignty over the islands through the United Kingdom's ability to satisfy each criterion. During the time from when the United Kingdom re-established a colony on the islands in 1833, affecting occupation to the present day. The islands under the government of the United Kingdom has cultivated a permanent population through the...
Can you wrap it up in 1 minute?
Yeah.
Thank you.
The UK has cultivated a permanent population. They're exercising government over the territory, and through import and export contracts and trade agreements, they've proven their ability to enter into relations with other states.
Our second question, which was looking at self-determination, we've fully answered that within the speech already, and Patrick will just quickly sum up our final question for you now.
The final question was Resolution 2065 sought to invite both the UK and Argentina to commence peaceful negotiations for the sovereignty of the island. However, in the question put forward by Jimmy Burns in The Land That Lost Its Heroes, how Argentina lost the Falklands War, it described that the Falkland Islands raised issues of sovereignty, self-determination, and the justification of extraterritorial military action, which gained new relevance in the new millennium. So the issue was, how can the United Nations have a valid role in international law when Resolution 2065 sought to determine and resolve this?
You need to wrap this up. Can you do that in 30 seconds, please?
Yes, I can do this in 30 seconds. So the resolution sought to resolve it, however, both entities ignored it. The UN Charter provided legitimacy for the UK to use force under Article 51. So the basis of international law requires that there is an element of consent. Such consent allows the UN, the ICJ, to resolve the dispute through arbitration. However, in the islands case, it was and continues to remain unresolved, created an unsatisfactory outcome. Yep, done.
Okay, thank you. So thanks for the group. Thanks to the group. I appreciate the use of images and the use of bullet points, which just encapsulated the key points of your presentations. And I also particularly like the presentation in terms of the basis for the claims of sovereignty by both the UK and Argentina in the way that they were juxtaposed to each other. So that's really good. In terms of my comment though, I would encourage the group that as far as a discussion of the relevant rules and principles pertaining to international law are concerned, they need to be directly connected to the facts instead of just speaking about them in general or in abstract. That to me was the key limitation there of the presentation. Which brings me to my first question, if it's all right. What is the relevance of the Montevideo Convention on Statehood here? Why are we even talking about that?
So we have a few issues where, so this is going back a little while, this is where it gets confusing because there's a big history to the Falkland Islands. Way back in the day, this is when they were first arguing about the islands. So this is early in the dispute. A lot of things are coming out where Argentina was claiming there was an implanted population there, and there was a few other claims, again, along those lines. So it's important to actually point out that it is, in fact, its own state. Because
hang on. Can I just stop you there? I'm getting confused. Is there a claim by Argentina that the Falkland Islands is a state of its own?
So the issue with Argentina's case is historically they've tried to claim that it is not in itself a state, but rather a military base by the UK. Now, while this isn't necessarily important to the current case, this historical background has kind of flowed into their current arguments, which is why we're seeing Argentina using 15th century and some rather outdated customary laws when we have new laws and new resolutions which kind of disregard old custom.
I'm still getting confused here. What is the relevance of the Montevideo Convention on Statehood here? Is there an assertion by either the UK or Argentina that the Falkland Islands is a state? Or is it just a claim really that the Falkland Islands is part of the territory either of the UK or of Argentina? And in that case, therefore, why should the Montevideo Convention on Statehood be relevant?
This comes into then the move of the United Nations to further decolonization. So self-determination is tightly linked to decolonization. And when you look at self-determination, you must also consider the movement of non-governing territories into self-governing territories and thereby becoming their own states.
Wait, so are we saying that the Falkland Islands is a state, or there is an attempt to make it a state? Is that it?
Basically, Argentina's attempted to highlight that the UK doesn't satisfy all the requirements for statehood in governing over the Falkland Islands. And that's something that's come up a lot in our research.
It has also come up in the recent United Nations conferences where the President of Argentina has also confronted the United Kingdom Parliament.
Wait, I don't get that part there, because
Not many people do. Argentina kind of tends to go around in some funny circles.
Yeah, because the Montevideo Convention actually identifies the elements that would then say that a state has been constituted. But I don't think there is any claim that the Falkland Islands is a state of its own. In fact, the assertion is it is a territory either of the UK or of Argentina. So I'm just wondering what the relevance is of the discussion about the Montevideo Convention is about. That's getting me confused.
No, we'll take that on. We'll take that on board.
Okay. Now, I think the bigger question really is who has been exercising sovereignty over the Falkland Islands? I think that is a question there that you need to confront. Because if it is correct that it is the UK that was actually exercising sovereignty over the Falkland Islands, then it would be correct to say that that Argentina invaded the Falkland Islands, and they used force in breach of customary international law. If, on the other hand, sovereignty was in fact over the Falkland Islands was in fact exercised by Argentina, then it's difficult to characterize the actions of Argentina as being an invasion, because they were the ones who had sovereignty over the islands themselves. So I think that is a matter that you need to kind of tease out, because that, in a sense, we're casually using the word invasion, but in fact, the use of the word invasion, where's that background noise? I'm gonna mute everyone for now. There's so much background noise. Okay. The assertion of invasion presupposes that island, that the state which is meant to have been invaded, the Falkland Islands, does not in fact have sovereignty over the islands. Because if Argentina does have sovereignty over the Falkland Islands, it can't possibly be invading its own islands. Perhaps it would have been using self-defense on the assumption that the UK had unlawfully used force in claiming the islands in the first place. So it goes to the question of sovereignty over the islands, as opposed to the question of statehood, which I kind of have difficulty understanding there. So that's one. I'd like the group to consider that in relation to the individual research essay. Now, the other point I'd like to ask is, I think the group cited 3 UN resolutions concerning self-determination, which you then say would actually be a legal support for assertions about claims of sovereignty over the Falkland Islands. My question is, are the UN resolutions a source of law in international law? And can the UN resolutions actually lay the basis for any legal claim concerning sovereignty and as a way of resolving the dispute between the UK and Argentina? So I'm looking at the legal authority in international law of the UN resolutions. You're gonna have to unmute yourselves because I muted all of you. I was getting too much background noise. So if you wanna speak up, please turn on your mics.
So I'd just like to quickly point out, with the United Nations resolutions, they were actually, sorry, we didn't realize the camera's mic'd, just 2 seconds. They're actually in regards to the United Nations calling for a peaceful resolution to the conflict, not in itself to self-determination. The first one, the resolution 1514, was actually the United Nations calling for either the right to self-determination or the decolonisation of the territory to be given back to the Argentina. So the resolutions themselves were actually more to do with calling for a peaceful resolution and for no more conflict.
So why are we citing these UN resolutions in the first place? What do they have to do with the conflict or in resolving the conflict? Are we speaking of the angle as a political solution that we're talking of?
So these resolutions were a lot to do with moderation and trying to get the ICJ to be more involved in the dispute. So having them sit down and moderately discuss, look at the legal principles, who actually owns it, rather than rushing to war. That's what the first 2 resolutions probably laid in.
Perhaps I should be more specific. can the UN resolutions be a basis to legitimize a claim of sovereignty, for example, over the Falkland Islands by either the UK or Argentina? So let me repeat. Can either the UK or Argentina base their legal claims of sovereignty over the Falkland Islands on the basis of a UN resolution or any UN resolution? I'd like to clarify that.
Yeah, so the resolutions provided the means to negotiate and yes.
They were rather a means to negotiate rather than as a matter of law. So it was a call for both countries to sit down at the table, look at the law and the legal principles, look at the history of it. And there was also, in the last few months, there's been one that's actually being tossed around the United Nations at the moment to do with Argentina trying to invade the waters. So we're seeing more and more the United Nations resolutions actually being used as a legal point. These resolutions we refer to, though, are more of a call to negotiate.
So are they a source of law? Can they be the basis of any legal claim?
They can be, but in this case, they've more or less been a way to maintain international peace.
If you say, Patrick, they can be, are you saying that that is a source of law? Can UN resolutions be sources of law in international law?
If they are ratified, yes.
You write it. That's not the way it works. You don't ratify a UN resolution. It's just a resolution.
Sorry, I got confused a second there. I more meant the international agreement that you would ratify that may come from a United Nations resolution. That was my mistake.
So what I'm actually doing now is to just flag to the attention of the group the very casual way by which you've been using the UN resolutions. Be aware that the UN resolutions are not sources of international law, and therefore they cannot be the basis of any legal claim. For example, either by the UK or Argentina to say that they have sovereignty. So the UN can, issue whatever UN resolution it likes, but that cannot be the source of any legal authority. Okay. And you have to distinguish, therefore, actions of the General Assembly from which the UN resolutions emanate, as opposed to any decisions made by the ICJ or even by the UN Security Council. So I'm just flagging that to the attention of the group because I'm just very concerned with the use both of the Montevideo Convention as well as the UN resolutions, which might not be the appropriate way to approach the problem concerning the Falkland Islands. Okay?
Yes, thank you for that feedback, Manju.
Okay. So with that, would there be any questions or comments on the group? I'm happy to end tonight's tutorial.
Manjo, when do we get our marks, if you don't mind?
I'm going to give the marks tomorrow morning.
Okay,
I'll send you them tomorrow morning. Okay, so I'm very pleased with the presentation of both groups. And I encourage you to take on board any comments and feedback I gave tonight. So the questions I asked were actually ways of providing you feedback, that there might be certain weaknesses in your presentation and analysis, which you need to address in your individual research essay. Okay, so that's my way of flagging some shortcomings that I see. So I hope you take them on board. Okay, so well done to both groups, and I hope to see you again. Congratulations, it's week 12. It's the end of the term.
Thank you.
Okay. Good night, everyone. Bye.
Bye.